Hi, I'm Yongchen. I'll be talking about question 1. Here are the facts. First, Jessica engaged Lawrence for conversion work of tea shop and Jessica residence. Second, there's a lump sum payable of 100k. Third, Lawrence completed residence but abandoned construction site. Lastly, Lawrence claimed that Jessica owed him 40k for work done on residential part of the project. The issue is whether or not Jessica is obliged to pay Lawrence based on discharge by performance. We identify precise performance rule as the law. The precise performance rule states that a contract is discharged by performance when all obligation in the contract is fully and precisely performed. However, there are 6 exceptions to the precise performance rule. Please pause the video to read on it. As for the application, based on the precise performance rule, the lump sum contract between Jessica and Lawrence is not discharged by performance as Lawrence did not fully and precisely perform all of his obligation. He completed the renovation of Jessica's residence but abandoned the renovation of the tea shop for more lucrative contract. As there is no full and precise performance, Lawrence will have no claim for any sum due under the contract. However, there are exceptions to the rule. Firstly, under the de minimis rule, it is not applicable as the deviation of not renovating the tea shop is not microscopic and thus cannot be ignored by Jessica. Second, under the divisible contract, it is not applicable as there was no intention of the parties to treat the renovation of tea shop and Jessica residence as separate and independent due to the agreement of lump sum payment of 100k payable on completion. Third, under the substantial performance, it is not applicable as Lawrence's partial performance does not constitute substantial performance due to the absence of renovation for tea shop, which was Jessica's main intention of purchasing the old Victorian building. Fourth, under the prevented performance, it is not applicable in this case as there is no mention of uncooperativeness by Jessica, which will prevent Lawrence from performing his duty. Fifth, under the partial performance, it is not applicable. Lawrence abandoned the contract without completion, leaving Jessica with no choice but to accept the partial performance. Lastly, apportionment act is not applicable as the renovation of Jessica's tea shop and residence does not relate to obligation to pay that is not of a periodic in nature. In conclusion, there is no discharge by performance. However, there is discharge by reputatory breach, as Lawrence renounced the contract. Therefore, Jessica is not obliged to pay Lawrence 40k as she can sue for damages. Now I'll pass my time to Aloysia who will finish off question 1. Thank you.
Thank you, Yongchen. Hello everyone, I'm Aloysius Goh and I'll be covering part 2 of scenario 1 on Jessica's rights and obligations against Chris. So the facts of the case are as follow. As I'll only be covering the key points, do pause the video if you need more time to read the passage on the left. In this case, Jessica engages Chris for the renovation of the tea shop for $80,000 and Chris manages to meet the deadline. However, Jessica refuses to pay due to unsatisfactory work as a result of defects such as kitchen door opening inwards instead of outwards and the shop service counter slopes from horizontal. The cost of remedying defects amount to $1,000. So, the issue. Is Jessica obliged to pay Chris based on discharge by performance? Now, I'll be covering some of the law that applies to this case. As the law in this case is similar to the law that has already been mentioned by Yongchen, I will briefly go through them. The precise performance rule states that a contract is discharged by performance when all obligations in a contract are fully and precisely performed. Some exceptions to the precise performance rule are the de minimis rule, divisible contract rule, prevented performance rule, partial performance rule, apportionment act, and substantial performance rule. Now, application. Firstly, the contract between Jessica and Chris is not discharged by performance based on the precise performance rule. Though Chris fully performed his obligation, it was imprecise, which led to numerous defects. In this case, Chris managed to complete the renovations to the tea shop by the stipulated time, but there was numerous issues, such as the kitchen door opening inwards instead of outwards and the shop service counter slopes from horizontal. These are evident that Chris' performance was exact but not precise. As there is no complete and precise performance, Chris is not entitled to payment under the contract. However, there are exceptions to the precise performance rule that we can consider. First, the de minimis rule is not applicable as the improper installation of the kitchen door and service counter slopes from horizontal are not microscopic and thus cannot be ignored by Jessica. Second, the divisible contract rule is not applicable as there was no intention of the party to treat the renovation of the tea shop as separate and independent. There was a full payment of $80,000 stated in the contract. Third, the prevented performance rule is not applicable as in this case, there was no mention of uncooperativeness by Jessica, which prevented Chris from performing his duty. Fourth, the partial performance rule is not applicable as Chris fully performed his obligation under the contract, which was to renovate Jessica's tea house by the stipulated time. Fifth, the Apportionment Act is not applicable as the renovation of Jessica's tea shop does not relate to obligations to pay that is of a periodic nature. Lastly, the substantial performance is applicable, though Chris' performance of his obligations was imperfect due to defects such as the kitchen door opening inwards and the shop service counter slopes from horizontal. It was substantial as he completed the renovation by the stipulated time, fulfilling the essential purpose of the contract. Therefore, Chris can claim a contract less sum needed to rectify his defect amounting to $1,000. So the conclusion, Jessica is obliged to pay Chris $80,000 less the cost of remedying this defect of $1,000, which amount to $79,000 based on the substantial performance rule. Now I'll pass the time to Jin Hui, who will talk more about scenario 2. Thank you.
I will now be discussing scenario 2. From the scenario given, we can determine the following facts. First, Luke was hired to design a website for $1,000, and Jessica was to pay him only after he hands over the website. Next, Luke had already begun research for the website when Jessica calls to cancel the contract. Lastly, Luke decides to complete the work regardless of the cancellation and bills Jessica for the $1,000. In this case, we have to determine if Jessica is obligated to pay the $1,000. Here, we can apply what we have learned about the discharge of a contract by breach. A breach of contract occurs when a party fails to perform his obligations under the contract. For a breach of contract to result in discharge, the breach must amount to a repudiation, and for a breach to be considered repudiatory, it must first be a breach of the condition, then a fundamental breach, and lastly, a breach of warranty which entails serious consequences. Moreover, as I will explain later in this video, the breach is also anticipatory in nature, and for Luke to have the right to affirm the contract upon an anticipatory repudiatory breach, he must first claim a fixed sum as opposed to unliquidated damages, second, not require the cooperation of the party in breach, and third, have a legitimate interest in continuing or performing the contract. If all three conditions are fulfilled, Luke can affirm the contract and Jessica is obligated to pay him $1,000. Now that we understand the law, to find out if the contract between Jessica and Luke is discharged by breach, we must first determine if the breach is repudiatory and anticipatory in nature. For the former, all three conditions are fulfilled. First, under breach of condition, the term was for her to pay the $1,000. However, she cancelled the contract and did not pay as a result. This means that Luke is deprived of the $1,000, which is a fundamental breach of contract. There was also the implied term that Luke gets to showcase his work in order to secure other similar projects. If he doesn't get to showcase his work, he wouldn't be able to secure similar projects, making this a serious consequence for Luke. Thus, there is also a breach of warranty which entails serious consequences, making the breach repudiatory. Moreover, the breach is anticipatory since Jessica cancelled the contract, meaning that she expressed an intention not to pay the $1,000 in advance. As for whether Luke had the right to affirm the contract after this breach, based on what we know, Condition 1 is fulfilled as he is claiming a fixed sum of $1,000. Condition 2 is fulfilled since he can finish the website without Jessica's help, and Condition 3 is fulfilled as he has a legitimate interest in continuing the contract, as seen from the statement in the passage. He decides to complete the work regardless of Jessica's wishes. This sentence also means that he has affirmed the contract, and thus, we can conclude that Jessica is obligated to pay the $1,000.
Thank you, Jin Hui. I'm Jimmy, and I'll be covering scenario 3 on Jessica's right and obligations to Tea Limited. Let's start off with the case facts. Jessica ordered 200 units of 1.2 liter teapots from Tea Limited. She has made it clear that the stated dimension was so that it could fit nicely on her shelves. However, the teapots arrived in 1.25 liter instead, and she could not fit the teapots on the shelf due to the extra 3 millimeters footprint. Hence, Jessica refuses to accept the delivery. However, Tea Limited argued that she could not refuse the delivery for something that is so trivial. So this brings us to the issue. Can Jessica refuse Tea Limited's delivery? The applicable law here is the precise performance rule, which states that a contract is discharged by performance when all obligations are fully and precisely performed alongside with 6 expectations to this rule. Since Yongquan and Aloysius has previously covered this, I'll move on to the application part. The first exception to the precise performance rule is the de minimis rule, which is applicable in this case. However, this rule does not work in favor of Tea Limited, as the deviation, which is 3 millimeter difference in each of the teapot footprint, is not microscopic, considering the fact that there are a total of 200 teapots to be placed on the shelf. The other 5 exceptions are not applicable in this case, as explained on the slides here. Do pause the time if you need time to read through them. We can conclude that the contract was breached because the teapots did not correspond with the specified description of 1.2 liter, and this deviation is not considered microscopic. Hence, the contract cannot be deemed as fully performed, and Jessica has the right to refuse Tea Limited's delivery on the basis that the performance is not precise. Since there was a breach of contract as stated earlier on, the other issue we have now here is whether Jessica is entitled to end the contract with Tea Limited. So based on what we covered previously, this is a case of an actual breach of warranty which constitutes serious consequences. The applicable law here would be the case of RDC Concrete. Jessica has made it clear that the teapot's dimension was to be 1.2 liter so that they could fit nicely on her shelves. This term is likely a warranty because it does not seem vital to the contract from the way she mentioned it. Due to the wrong dimension, Jessica cannot fit all the teapots that she has ordered on the shelves. I believe that this is a substantial deprivation of their benefit, as she will not be able to display and sell all the teapots. Since this was a repudiatory breach of contract, Jessica can choose to terminate the contract and sue for damages or affirm the contract. Now I'll pass on the time to Fabian to cover the last scenario.
Thank you, Jeannie. Hi, I'm Fabian, and I'll be going through part 1 of scenario 4. Scenario 4 is advising Jessica regarding her rights and obligations as against Deepak. Here are some facts of the case. Jessica decided to sell the tea shop to Deepak, and Deepak signed a sale and purchase agreement, and a sum of 500,000 is to be paid by Deepak as a deposit, and the remaining 1 million to be paid on the date of handing over possession to Jessica. However, the Singapore government acquires the entire land and building on which Jessica's tea shop is situated for the use of a public museum. Therefore, Deepak does not wish to be burdened with a tea shop that will be acquired by government soon, and Deepak refuses to pay the remainder of purchase price and also asks for the refund of the initial deposit. Therefore, the issue is, can Deepak end the contract with Jessica and be refunded his initial deposit? Moving on to the law, the applicable law here is discharge by frustration, where supervening act due to no faults of party renders the venture enter into radically different from that which the parties originally contemplated. And due to government intervention, Shen Ying versus Commerce Bank, 2001, offshore iron market wiped out due to Malaysian government law that led to discharge by frustration. We'll also be examining the factors that limit frustration basis based on, firstly, foreseeability. The more foreseeable the supervening event, the less likely situation will amount to frustration, using the case HDB versus Microform Private Limited. Secondly, force majeure clause, express term in contract providing for what is to happen between the parties upon occurrence of events not under human control. And lastly, self-induced frustration, where the party seeking to rely on frustration is at fault, using the case Maritime National Fish versus Ocean Trawlers. We'll also be examining the effect of frustration using the Frustrated Contracts Act. The definition of effect of frustration is contract automatically discharged and all future obligations cease, and losses lie where they fall, and money paid before discharge by frustration is recoverable. All future obligations of parties is ceased, using the case Fibrosa Spoca Exigena versus Farban Lawson Combe Barbour Limited, 1943, and using Section 2 of Frustrated Contracts Act, when money paid prior to time of discharge is recoverable, and money payable ceases to be payable. Now, I'll pass my time to Min, who will go through the application and conclusion of scenario 4.
Thank you, Fabian. Hello, I am Min, and I will be going through the second part of question 4, the application and conclusion. For the case of Jessica and Deepak, the contract can be discharged by government interference, which is a type of frustration. The Singapore government, which is an external party, acquired the land to build a public museum. This act of government interference was unexpected and prevented the selling of the tea shop from Jessica to Deepak. The failure of performance is also due to an external factor that is neither the fault of Jessica nor Deepak. Hence, it can be seen that government interference has caused the very basis of the contract to be destroyed, such that the venture to which parties now find themselves committed to is radically different from the original. However, there are certain factors which limit frustration. Firstly, there is foreseeability. This is not applicable in this case, as the act of the government acquiring the land is likely to be unforeseeable by the parties. Secondly, there's force majeure clause. This is also not applicable in this case, as the contract did not include any force majeure clause. Thirdly, there is self-induced frustration. This is also not applicable for this case, as the supervening event was not a result of any voluntary action by either parties. Instead, it was caused by the Singapore government, which is an external party not involved in the contract. Since none of these factors which limit frustration is applicable, frustration can operate in this case. In conclusion, the contract between Jessica and Deepak is automatically discharged under frustration, effective immediately. Jessica is also obliged to refund Deepak the initial deposit of $500,000, and Deepak is not required to pay the remaining sum of $1 million under Section 2 of the FCA. Thank you for your kind attention.